Hi, Tony DeWitt here, a Missouri appellate attorney and a guy who answers questions on YouTube. Today we're going to be talking about relevant evidence, so stay tuned. The test for relevant evidence is pretty much the same throughout the country. A lot of states use the federal rules of evidence as a model for this issue. And the federal rules of evidence, specifically Rule 401, says that the test for relevant evidence is whether or not it has any tendency to make a fact more or less probable than it would be without that evidence. And that is of consequence. The fact that seeks to be made proved or seeks to be proved through the evidence is of consequence to determining the action. So one thing that needs to be sort of fleshed out here a little bit at the beginning is that there is a big difference between conduct of a deposition, where lawyers are in the process of discovery and they're asking questions, in terms of relevance as opposed to actual evidence in court. For example, in a deposition, a lawyer could probably ask a doctor about other types of surgeries he's performed. Let's say that there is a medical negligence case that is a result of a bad knee operation. The doctor put this knee in, this artificial knee, and it failed, and the patient is, unable to walk now. So they've sued for malpractice, and in the deposition, the doctor might be asked about other surgeries. You've done laminectomies. Well, yes, I have. And you've done heel spurs. Yes. And you've fixed hands. Yes. And you've casted broken legs. Yes, you can answer all of those questions. Because even though those are not relevant necessarily on the issue of what he did with the knee operation, they are nonetheless liable to potentially lead to other admissible evidence. And so there's a lot of things that a lawyer can get into in a deposition that he can't often get into in a court of law. So when we talk about relevance, we're talking about relevance in terms of getting a fact admitted before a court in a court of law during a trial. So let's go back to that analogy. Let's suppose that the doctor is on the stand and he is being examined by the plaintiff's counsel in a medical negligence action. And one of the questions is, you admit you did the knee surgery at issue in this case? The doctor would say yes. And you admit that you've done laminectomies before. And at that point, the opposing counsel is going to jump up and object because it is not relevant. It doesn't have the opportunity to make a fact more probable in a case involving a knee when you're asking about a back surgery. It's only facts that are of consequence in determining the issues before the court that are relevant. Now, let's also suppose that there are questions about that go to a particular witness's bias. For example, someone might say, you've been involved in a number of collection lawsuits. Somebody might object because that's irrelevant. The lawyer might very well say, well, this goes to bias because it shows that he's biased against a particular lawyer or a particular doctor who may have sued him, or doctors generally who sued him for medical bills. A witness's bias is almost always relevant. A witness's opportunity and motivation to lie is almost always relevant. It's one of the reasons why when expert witnesses are placed on the stand, usually the person doing the deposition or doing the direct examination of the doctor will say something like, and you're being paid for your testimony here today, correct? Yes, I am. And how much are you being paid? Well, I have to be able to cover the expenses of my office for a full day when I'm in trial, so I charge $1,000 a day for trial testimony, and that pretty much covers my overhead at the office for that day. So they do that to take the sting out of the fact that after they say all these things that the other doctor did wrong, the defense counsel won't come back and say, well, you were paid $1,000 for your testimony. Because the answer will be no, I wasn't paid for my testimony, I was paid for my time away from the office. Those are just some of the things that come up in the course of relevance discussions. A witness's bias, a witness's motivation to lie, those are always relevant. But there are a lot of things that are not relevant, and some of those things are covered by other evidentiary rules, which we'll get into here in several other videos that I'll be making here shortly. But the main thing to remember is that in depositions, there's an awfully broad scope of relevance. And even in trial, there's a fairly broad scope of relevance. Here's how this works at a trial court level. A trial court can make an error with regard to the admission of irrelevant evidence. It might very well admit something that it shouldn't admit. That technical rules of evidence might forbid it from making that piece of evidence available to the jury. But when it goes up on appeal, on the appeal, the appellate court will grant deference to the trial court on most of these issues. And only if that evidence was extremely prejudicial in most cases is there going to be a reversal. If there is some chance that it changed the verdict and it was irrelevant, then it may very well cause the case to come back and be tried again. But for the most part, the admission of irrelevant evidence and the determination of whether something is relevant is within the purview of the trial court. And that is done primarily just to move things along. You don't want to have cases going back and forth between the appellate and the trial court on individual evidence issues. It's very, very rare in my experience to see a case reversed on an evidentiary point unless there is some significant chance that that evidence changed the verdict. So that's the story of relevant evidence and how Rule 401, Federal Rule of Evidence 401, affects the admission of evidence in a trial. I hope that's been of value to you. If you have any questions, please leave them in the comments down below. And if you would, I'd appreciate it if you'd like and subscribe. If you haven't already subscribed, please like and subscribe. Otherwise, just like the video. It helps a lot. And besides, it makes you feel good all over when you like a video. You know, you just feel like you've done something important. It always makes you feel good when you like a video because it's a wonderful thing you can do for somebody who's making videos. It feeds the YouTube algorithm, and in my case, when I see likes on a particular type of subject of video that I'm doing, then I go and I make more videos about those types of topics, basically because I want to make sure that you're happy at the end of the day. So thank you for watching and have a terrific day.